Welcome to the Crypto Compliance Podcast by Gatenox.
Welcome in Crypto Compliance by Gatenox. Today I am with big group of lawyers, where we're going to talk about primarily things happening currently in crypto market, especially around FTX, Sam Bankman, and what is relevant for many people in crypto assets recovery and what we can do with it. Right, so I'm here with Kaufmann, Philip Kazantzis, Anthony Metzer, and Eric Lewis. And I'm gonna, guys, if you can help me to introduce yourself, that would be great. Coming from my left, Adam, if you can say a few words about you.
Thanks, Pawel. Hi, Adam Kaufmann. I've been a partner in Lewis Bach Kaufmann Middlemen for the past almost 10 years exactly, actually. Before that, I was a prosecutor at the Manhattan District Attorney's Office, where I, at one point, was the chief of the International Financial Crime Bureau under Bob Morgenthau. Thanks.
Sounds great. So we have the U.S. coverage. Eric, that's on over.
I'm Adam's partner. I'm chair of the firm. I've known Adam for a long time and his office. I've do complex. We're an international litigation boutique. We do complex financial fraud and asset tracing, and we're based in New York and Washington.
Sounds great. Philip?
I'm a barrister based in England, working just outside London. I'm a sole practitioner, so I practice on my own account rather than being a member of chambers. I'm dual qualified, so I'm also a solicitor. We have that difference in England, but I've been practicing as a barrister since 2004 and largely dealing with fraud trials in the UK, England and Wales, actually, I should say. And so mainly defence work, but I also conduct some private prosecution work and deal with confiscation proceedings.
Thank you. Anthony?
Good afternoon. I'm Anthony Metzer, KC. I'm a senior barrister, a King's Counsel now, and I practice in crime, in civil, and immigration, and relevantly for the purpose of this podcast, have experience particularly in areas of fraud, both criminal and civil, and some experience also in extradition and in asset recovery. I also sit part-time as a deputy High Court judge, deputy being a word which not everybody necessarily will understand, means part-time. So I sit as a part-time High Court judge, and I also sit in a couple of other jurisdictions as well, one in immigration and one related to war pensions, perhaps of less relevance to now, but I'm looking forward very much to this podcast. Thank you.
Excellent. So I think, there's a lot of happening, as I said, in crypto world, FTX being, one of the critical element of this. And there is some interesting news. One of them is, and this is where I want to start with this, is what's happening with the assets lost or defrauded or stolen, whatever we call this, in the process. I mean, from coming to FTX, there is the U.S. Attorney's Office for Southern District of New York has announced the formation of the FTX task force to handle this type of inquiry and investigations. So I think it's. And, my background is as well, crypto compliance, tracing, and I know how difficult it is to recover the funds in crypto. But effectively, we have two, let's say, aspects here. One is the fiat, the traditional currency, which is put to FTX via bank accounts, I think, especially through Silvergate and a couple of other US banks. And then we have crypto assets, right? So what would be your suggestion? And let's start with Eric, what you can do, if there is anything you can do, when your funds are part of this, FTX fraud case.
Well, it's a complicated situation because it looks like at least $8 billion of customer funds were funneled out of FTX into Alameda, and they've made some very large and risky bets, and they may be lost. The first question is, what priority do the customers have? Under their contracts, these are personal assets. They are not deposits in a bank, which would just be treated as a debt and you'd be a general creditor. If I lost money as an FTX customer, I think what I would be trying to do is filing lawsuits. Either there are a number of class actions or filing my own, asking for an injunction on any payout of anybody and seeking a first priority for my deposits. I think, sadly, there are going to be very large losses because the money seems to be gone, and I don't know how much is going to be recovered in that way unless they can find counterparties or others who are complicitous, who can be sued for participating in the fraud or having some other liability. It could be suing accountants. It could be suing others who may have some complicity. That's likely to be your best source of funds, but I think it's going to be difficult. Unlike Madoff, where most of the money was there, here it appears that most of the money is gone. And unless you can find responsible parties who are solvent, and Bankman-Fried appears not to be, I think there are going to be very large losses.
So in other words, is this because it was transferred to other entity, Alameda, right? And that's why it's going to be difficult, because there is disconnection between where you put the funds and kind of who benefited from this, correct?
That's right. Adam, do you have some thoughts on recoveries, at least in the U.S.? And I would think our English colleagues do as well, in terms of what injunctions are available and what discovery tools may be available to find and trace funds.
Thanks, Eric. I do have a few thoughts. I mean, one thought to start with is that I think people are ultimately going to be very disappointed, because I don't think there's going to be a lot of funds to recover. A lot of the media has focused on incredible houses, real estate property, the lavish lifestyle, and that may get you tens, perhaps even hundreds of millions of dollars, which is certainly substantial. Dealing with recovering those in different jurisdictions is its own issue. But, here we're talking about a loss of billions. And so a recovery of $150 million is really not going to go very far. So I think from an asset recovery perspective, one of the interesting things I've seen is that in Madoff, you had a lot of money clawed back from the feeder funds, right? And so there was fiat currency that existed in these funds and that had gone out, payments to investors that could be clawed back. From what I've read and from what the CFTC has alleged thus far, it looks like a lot of this money is tied to the collapse of a Terra stablecoin. I don't know why they're called stable coins. I think they're anything but stable. But FTX, Alameda Trading had an exposure to this risky crypto investment with Terra, from what's been written, and it looks like when Terra crashed, Alameda had exposure, and to cover that hole, it sounds like they dipped into FTX to the tune of a few billion dollars, and that money went out to try to prop up Terra. So, to me, it looks like that money is probably gone, and that's billions of dollars of account holder money that probably is not recoverable.
What do you think? What do you think, Adam, about the possibility of going after some of the entities that it's been suggested try to sort of launch an effort to take down FTX and destabilize it as a possible route. Some of the, there was that entity that was going to acquire it and then
Right.
didn't. And
it's interesting. I mean, I think the problem with going after those is that, don't you think that you're going to have a causation problem, right? Because ultimately, if you have insider fraud, then won't those entities going to say, we were right? We were just, we were saying bad things about FTX and we were right. There was fraud going on. And you had this lack of controls. It's been very well reported. You have the CFTC or the prosecutors. I've heard one of them saying that Alameda treated FTX as an open line of credit pretty much from the beginning, borrowing freely from it. And then after this money was shuttled out to cover the Terra crash, you had some accounting irregularities internally to try to cover the hole and isolate it and put it off balance sheet. And so I think that the internal fraud would be, if you were defending one of those entities, right, you would just say, how can you come after me? There's all of this internal fraud. I didn't cause this collapse.
Yeah, well, the emperor had no clothes. We just happened
Called it
to
out.
pull back the curtain.
Yeah.
So let's say so we have the situation when we have U.S. Let's say citizens, right, investing in FTX. So they had this money is protected, right, because they put the money in FTX US, correct? Or is it also, the gap is there?
It's not protected. It's not insured by the Federal Deposit Insurance Company.
True.
It's not. There's no. All they can say is that it is considered a unique good, like a gold coin. That is, there was no. They never surrendered the asset in return for a claim on the assets of FTX. They surrendered. They basically had their money stolen, like out of a safe deposit box, and so they can.
In the moment of transfer.
That's right.
Okay, that's interesting. From the UK perspective, right? If we say that, is there any stronger claim, considering that in the UK you have this treatment as property of, crypto assets would be treated as property, so effectively you've given someone your property, and do you have, you have special injunction on this. Is there any stronger case to recover if you are, citizen of the UK, or, you have any claim from the UK to FTX?
Well, there's no insurance on this side because it was not a registered company with the Financial Conduct Authority here. So there's no financial regulation by them. If it were regulated here, then there would be a limited amount of cover from the Financial Conduct Authority, but that does not apply because FTX was not registered in the UK. The difficulty is, again, as others have said, if there are no assets or a very limited amount of assets, what is there to freeze? Where do you locate the asset to freeze? And that may be something that Tony can touch upon. He'll probably have more experience than me in that regard on the civil side. But it's, are you then throwing more good money after bad? One of the regular things that comes up.
But hold on. If we say that crypto is fully transparent and traceable, right? And we have I paid Bitcoin to FTX, and then this Bitcoin was transferred to Alameda. Is the same Bitcoin. It's effectively the same as you could treat car, right? It's your car, and it's transferred to different places around the world. But effectively you still have it's your car. You just given this to someone to manage. Is this something? Is this relevant consideration, or? And I know that it's not easy. I've been through these cases, a lot. When we're tracing and trying to recover, funds coming from Australia to Singapore, US. it's crypto is crazy about it, and I think this is one of the biggest problem with crypto, that it's so international that it's simply switching between a couple of jurisdictions, and it's not possible to recover because of, let's say, different definition of what is crypto, different let's say laws applicable. So, but is there any relevant tool to be applied here? Tony, what's your thinking about this?
Well, I think, as others have said, and Pawel, you've really put the nail on the head here. The difficulty is that these are such difficult assets to trace, to identify. They can be presented in different ways in different jurisdictions. And I think the answer is, although Phil's absolutely right, the traditional way in England and Wales will be to seize onto assets. Assets, of course, are usually corporeal, so we can obviously see money or stocks or anything like that. You're absolutely right. In theory, any chosen action can be traced and can be sought to be restrained and recovered, and that includes, let's say, a good example, which is away from this example, is options to purchase shares, for example. They are the sort of things that can theoretically be traced. So it isn't necessarily something corporeal or physical. That said, I think there's a particular difficulty with this cryptocurrency, is that it has an ethereal quality which is very, very hard to trace. So not impossible, but even assuming, and Phil's absolutely right, that this would be a case which would come within the English and Welsh jurisdiction, which it clearly doesn't because of the issues that the FCA are not involved. The reality is, on top of extraterrestrial and international cooperation that's needed, is that this really is the type of asset that sort of disappears. It has a slight sense of that it just slips through your fingers, really. So I think the short answer is very difficult.
I think another issue to think about is the allegation is that investor funds were dipped into and somehow transferred out relating to that TerraCoin debt. And what I've been trying to think about is how did what was the mechanism that affected that transfer of value, right? Because we're talking about crypto. So if it was a transfer of, if I had stored my Bitcoin on the FTX platform and my Bitcoin was transferred over to TerraCoin in some fashion, then you could trace that on the blockchain. You could see my Bitcoin. Yeah. But I don't think that's what happened. And my fear is that what happened is that my Bitcoin and the Bitcoin of, 1 million, 2 million other investors was converted into some other currency, perhaps converted into TerraCoin itself. And then that mechanism, you convert it into something that crashes in value. Your value is now gone. And so you can't reach out and get that value back. If it had stayed in Bitcoin, for example, it would still exist and you'd still be able to reach over and pluck it back. But because there must have been some type of transfer, and I haven't read enough to know what that mechanism was. But to me, that suggests that whatever medium it was converted into is gone, that the value has crashed. It'd be like buying silver just before silver crashed. Your money has been converted into a different medium. That medium has lost value, and so your value is gone.
So, okay, but if we saying is a combination both of amalgamation, so yours gets absorbed amongst others and then converted. So you've really, it's a two-stage process that makes it really, really difficult to recover. Right.
And if we say if we say that the Alameda, all different entities which are part of this would be from the outset almost fraudulent, right? And everyone who benefited from this, and there's definitely, some people who benefited from this, if they knew this from the start, it's actually, fraudulent activity. Is there any recovery, on this basis? Is this helpful? Or is it going to be just simply, too remote to kind of say, right, this was fraud And even if we have like 20 different entities involved, it's still, let's say one group.
Well, I think it's a difficult situation. I suspect that what happened was that the Bitcoin came out of FTX accounts, it went to Alameda, and that Alameda probably monetized it in some way, and so that it then, got sold on. And I guess the question, and I think we're in uncharted territory here, is, if when Bitcoin is fraudulently removed and then sold on and monetized, can you then trace the Bitcoin to the purchaser or trace the money into where it was sold on to, assuming you have people who are taking for value and without notice? And I think the answer to that is probably, it would seem to me, probably not, that you're then going to start tracing these transfers, and you're ultimately going to find somebody who is, has nothing to do with Bankman-Fried or the others, probably didn't even know his account had been raided, and his Bitcoins, are now sort of traveling in one direction, and the proceeds are traveling in another. So again, I think it's very unlikely. I don't, and I also suspect they'll be hard to trace because the records of FTX are so bad, and probably deliberately so, because it appears from what I've read that they started to raid customer accounts from the beginning of the business and use those raids in order to finance their own investments in Alameda, and then the money got lost. So I really don't see, at the moment, unless there are some sort of regulatory changes, but there aren't going to be anytime soon. You could see, we don't really have it, but the English analog that I think of, and I'd be interested in Tony and Phil's views, is misfeasance in office by the CFTC and others. We don't have that particular tort, but it would seem to be a very interesting one, because here the SEC and the CFTC have been battling for years over who has control of crypto, and crypto behaves much more like a security than like a pork belly or a crop.
Yeah, well, that's interesting. Thanks, Eric. I mean, I think what Eric's point is, I think it's absolutely right. It'd be very, very hard to get to the fraudsters. We've got a whole, almost certainly a whole bunch of to use the old-fashioned expression, middlemen, some of whom may have knowledge, some of whom probably don't have knowledge. There's an analogy in a case in which we're involved in at the moment, which relates to trying to recover assets for the Yazidis, which are following the rape and sexual abuse of many of the women and girls. And no doubt there were substantial assets acquired by ISIS. And then the question is, what's happened to them? Have they made their way to Swiss banks? And almost certainly we understand that they've worked through middle people, say in Turkey, who may not have had the same knowledge as the circumstances in which these people were appallingly treated, and assets, money was taken off them, and you get them, inverted commas, cleaned up. You just get the situation by the time they get to the banks that you're no longer but purchasers with notice, that people don't understand the genesis of the fraud. So I think there's a real difficulty there. But so I tend to agree with Eric's point that going after the actual fraudsters is going to be very, very difficult. But I think his point is a really interesting one as to whether there's a civil claim which might be available. Certainly, there could be theoretically be available here in England and Wales in relation to misfeasance in public office, which is not really it's going after those who have duties to try and act properly. And essentially, a misfeasance in public office claim is about abuse of power. It's where there is a power to a public body. Often, in my cases, I've been involved. It can be the police, it can be the prison service, it can be government organisations, and where they have a power entrusted to them to act responsibly and appropriately towards individuals. So it's a private law remedy, but in the way they've abused that power in ways which are not identifiable in the other cause of action. So in the police context, it will be outside false imprisonment, malicious prosecution. It's essentially where there has been a misuse or an abuse of powers undoubtedly entrusted to them, and that's been done either deliberately or at the very least recklessly. Then there is a potential cause of action in tort available to victims who have suffered on the back of that. So that would be a really interesting area. Obviously, not going after the fraudsters, but going after those bodies who were intermediately involved.
I would also, I think it's worth spending some money on investigating whether it's possible there are any financial institutions or others that may have been on notice and working with them, or either on notice or should have known that funds were being taken from customer accounts. Particularly if, for example, some of these Bitcoins were used as security for some of the massive loans that Alameda took out to take positions that were then lost.
So that would be presumably a breach of trust, breach of constructive trust or resulting trust. That would be that type of claim potentially.
Yes, or just a claim in aiding and abetting fraud, which might get you into a deep pocket deeper.
Mm-hmm. Just wrapping up on this subject, from practical perspective, what would be the minimum of claim which, from the client, if you would be considering to take as your client, so what would be the minimum of money lost, to actually, I know, that, for example, I don't know if this changed, but majority of the clients, if it would be like 20, 100,000, nobody would actually help them, right? Because it's not worth it, basically. It's so difficult to recover. So I think, the threshold was around 5 million, at least a year ago or, 2 years ago, this is where, lawyers start to get interested in this subject. So what you reckon? Or is it class action actually, which is much more appealing here?
I mean, I'll say one thing that you would need a substantial number. You either need a really big investor or a substantial number of small investors. One thing we haven't even really touched on are the different classes of people with losses here, different classes of creditors. You have, as we've been talking about, individual investors, but we haven't really spoken about, private equity groups that may have invested tens of millions of dollars into FTX itself, not as proprietary funds of the investor, of the account holder, but as an investment in FTX, and whether they're going to have a senior secured status that will make it, much more challenging for individuals to recover. And so I don't know. I think before you even advised a client to get deeply involved in this, you'd really have to look at, the corporate structure is crazy. I've looked at a couple of org charts, and it's companies all over the world, jurisdictional questions. So I wouldn't even hazard a guess. You want to guess? I'll say 100 million would be a starting point as an individual or a group of investors.
Wow.
Right, because if you're a shareholder in FTX, presumably the people who've had their funds stolen are going to sit ahead of you. So the first 8 billion you get nothing. So that's a problem. As you know, we have contingent fee cases here. I would be very reluctant to do it at any amount of contingent fee case until things have clarified. But I agree. I think you're talking tens, if not hundreds of millions, where you're willing to take that kind of risk in this scenario.
UK,
In the UK, it's a bit different for Phil and me because we're barristers and stuff. We're protected from that type of decision. If a solicitor instructs us that they've got the funds in place or they're prepared to take the conditional fee agreement and we are on similar terms, we'll go with it. But I think you're getting a real sense from Eric and Adam that it will need a sizable claim. It strikes me in real terms. I mean, I'm slightly joking about because obviously technically, if you pay us enough, we'll take the case on if we think it's got enough merit to it. But the real question here is got to be whether this is a class action, unless there's someone really huge backers. Because most individuals, it's just not going to be worth it. In the UK, it will be solicitors and barristers level. So probably a class action, I guess, or some small number of very, very substantial backers. But given all the other difficulties, certainly if it's a private case, different questions arise. But if it is taken under a conditional fee agreement, it would need to definitely pass through a difficult screening in terms of overall merits, both in terms of the strength of the claim and in terms of the likely quantum, the likely damages you'd recover at the end of the day.
Yeah, I think this is one of the part of said message which is happening with crypto. That's why I think it's so risky asset still, and it's going to be for the next couple of years. But it is, I mean, even if to start any type of litigation, it's going to be very, very, very costly, right? Okay, so let's move on to Sam Bankman, right? And he on 21st of December. He was extradited from Bahamas to the US, right? And then, we had suddenly this incredible news after, I mean, it's actually next day, right? 250 million bail, right? Recognizance ban. And when he was actually released from jail, right? So first of all, could he stay in Bahamas? That's the first question which I had. Could he actually say, I don't want to be extradited, right? And was it actually a big mistake from his side? Frankly speaking, that's probably there's so many people in crypto which simply stay away from US and they simply, don't go to the US. And even, at some point we are making fun in the industry that there is a couple of jurisdictions when you can go for holidays, which is like, Iran, North Korea, and a couple of other jurisdictions when you will not be taken by force to the US, right? So, was it error on his side, mistake on his side, or anyway he would be brought over to the US? Eric and
sure.
Adam?
It's governed, the international extradition is governed by treaty, but it's in many ways a political process as well. He was being held at the Foxhole prison, which is also known as Foxhell. It's a pretty unpleasant place. He would have been held in jail until the extradition was finally decided. That could have been years. I think the Bahamas, one would have known fairly early whether he was going to be protected by the Bahamians or not, because the Bahamians have declined at certain times. My initial thought was, he might make a deal with the Bahamians to be tried in the Bahamas and to allow the Bahamas to ring fence assets. And obviously the Bahamians could have charged him too, because a lot of these crimes happened in the Bahamas. At least part of them happened in the Bahamas as well. I expect that he made a judgment that challenging extradition would not have been successful, that the fact that his girlfriend turned on him so quickly meant that they had the goods. I expect the next thing his lawyers might have done was find out whether he could get bail in the U.S., and when he got bail, and being able to be out pending trial, as opposed to being held in a facility, and then likely would have been put in a facility in Brooklyn or Manhattan when he got here, if he lost on extradition in a couple of years, I think all in all, maybe he made the decision that the least bad alternative was to come here. Having said that, he is looking at some very significant jail time, probably more than he would have gotten in the Bahamas, but he could have served his time in the Bahamas and then they could have brought him here. So he had no good alternatives. He might have had, he had certain standard defenses. For example, on the election law claims, he could have made it's a political case claim and a dual criminality claim, that he wouldn't be prosecuted for that in the Bahamas. But on the fraud claims regarding the crypto, there would be dual criminality. Also, there's the principle of specialty, where you can insist that no new charges are added. But given that he's looking at 115 years possibly in prison, he won't get that, but he'll get a lot of time. It's not like adding new claims in the U.S. would have, affected the length of jeopardy for a sentence. So I don't think he had many good options. I think he made the decision very quickly. I probably would have thought about it more. He seemed pretty impulsive about it. And I'm not sure how much time he and his lawyers had to go through all the options.
Yeah, I think 115 is currently, right, the charges, years in prison, right? So I think regardless whether this will be Bahamas, or US, it's probably long enough. Let's say theoretically, let's put this in this context. If this would happen in the UK, for example, we have FTX UK, not Bahamas, and for this type of, and we have Sam Bankman accused in the UK. Would you see, Tony or Philip, would you see this long term in jail? Because I think, one of the things which you can say exactly, so one of the things we can say about the UK is like, it's very light touch for this type of activity, right? This type of criminal things. What do you think?
Certainly much shorter sentences in the UK. And we have the same rule of specialty in terms of extradition. So if you are extradited, they cannot add any charges that are not already on the extradition warrant. So, and I'm quite surprised as well in terms of how quickly the decision was made. I would personally have wanted more time to review matters. But it's very similar in terms of how we approach the extradition, but sentencing-wise, nowhere near those types of figures. And of course, because of, the election ones would probably be made to run consecutively, but the fraud ones, I think Tony may have a different view, I don't know, would probably run concurrently. So any sentences would run next to each other than the ones that are different, such as the election fraud ones.
In the US, there would be a discretion. Remember, Madoff got 150 years. And this is, generally what would happen is you'd get them, they would look at what the maximum is on the most serious count. And that usually would form a top level, but it doesn't need to necessarily. And it would probably be, the guidelines would push you near the top of that. I think it's a 20-year count was the most serious count, because of the amounts. But this may well be a sui generis or a once in a generation kind of storm of fraudulent storm. Adam, what do you've called for a lot of sentencing recommendations? What do you think? What would you ask for?
What would I ask for here? I think he'll get north of 20 years. I wouldn't be surprised to see him get 25 years on this if he pleads early and accepts responsibility. He may get out someday. I think he's looking at just tons of time. I say that not knowing the details of the facts yet. I do think that the decision was made so quickly, probably as an agreement that he would get a bond package if he did not require the U.S. to go through extradition proceedings. So they probably made that deal quickly. That's probably why it was so quick. So that, and psychologically, if you are a criminal defendant who is in jail, and there is any chance of getting out of jail, even temporarily, and coming back to the U.S. and not being in foxhell, and not having to go into the horrible detention facilities pre-trial in the U.S., but to be out for that period of time, psychologically and emotionally, clients tend to grab onto that. If they can get out for any period of time, they want it. And I do think at the end of the day, extradition may have dragged on for quite some time, but I think at the end of the day, as Eric said, you would know, and I don't see any chance that Bahamas was going to give shelter to him for these fraud charges. The speciality is sort of not relevant. The indictment, it's a very quick, it's sort of a slapdash indictment. They clearly threw together everything quickly to try to they needed something to attach for the extradition proceedings if they had to do them. And so if you look at the indictment, it's very bare bones. It simply tracks the statutory language, which is legally sufficient under U.S. criminal procedure. You don't have to give much detail at all. I imagine that if he does not plead guilty, and if the case is going to move forward, we may well see a superseding indictment that has much more detail and speaks to what the crimes actually were. But again, I think that's another reason why, I wouldn't be surprised if we see, well, we'll see what happens next, but this, we don't know what the evidence is. I mean, the defenses, there could be many defenses, but I think often contesting extradition, depending on the jurisdiction and the type of case, can be expensive and can end up being harmful.
And the fact that his two sort of senior Confederates pleaded before really puts him behind a long series of eight balls, because I think they were in a position to know everything that was going on, and they're clearly going to portray him as the mastermind, and that gives him few places to move. And I think the focus now is keeping his parents out of it and getting the best deal he can, I suspect.
Yeah, I mean, I think it's interesting to hear all that. I mean, one doesn't know, but one can have a sense that this is probably going to end up without being in a full trial. Taking on what Phil said, if it were in the UK, I mean, Phil's absolutely right that the sentences in the UK generally are much shorter. That is partly because the sentence imposed is closely connected to issues about parole and license, particularly parole is built in. So obviously the idea of a sentence of 100 or 150 years in the UK, I think I can't imagine such a sentence ever being thought about. Even when we're talking about life sentences, there's always a tariff, which is we're at the absolute highest. We're talking a small number of decades. That's for the most heinous murders. But the other point is, which I think Phil touched upon, which I think is very important, is that in the UK, particularly, I could speak particularly about England and Wales, fraud is there's much less money allocated to it. There isn't the same tenacity, there isn't the same financial resources available, certainly in terms of the state, in terms of fraud prosecutions, which is why Phil and I and others have now done cases involving private prosecutions, that fraud is not prioritized in terms of financial resources and prioritized in terms of investigation, as it's clearly the position in the United States, which It is to their credit, and I'm sorry to say, I think it is rather poorly done here, and a very good example of that, because it deals with enforcement officers as well, whether that's to do with drugs or whether that's to do with fraud, is, for example, in relation to the HSBC scandal case. One can readily see where that obviously was connected to the Bahamas. We can see the extent of resources put in the United States in relation to that very, very large fraud, and that one just realistically could never see that type of investigation ever happening under British jurisdiction, in my view.
I would also note that under the federal system, you have to serve 85% of your sentence. So there is, whatever he gets, the discount as to when he gets out will be quite limited.
And that's for parole, is it, Eric? That's the earliest you can be eligible for parole.
Yes, you need to serve 85%, other than in extraordinary circumstances, like you have a terminal illness or something like that.
Right.
And Adam, you mentioned the bond package, right? It's $250 million. I mean, was it paid physically? Like how what's the mechanics around this?
So it's interesting. It's actually a bit of a mystery. The judge allowed the signatories, the guarantors. No, it's not paid. It's not cash bail. It's not a couple of giant bags of money being brought in. Nor is it wire transfers of crypto. It's an amount put down, and then guarantors for the balance. I don't know much of the details of this particular bond, but what was interesting was the judge allowed the identity of the guarantors to remain sealed. And so they're not known to the public, under the theory that they would have been subject to public scorn, to being attacked verbally or otherwise. And so to protect the guarantors, the judge allowed them to remain sealed and anonymous. Besides that, he is restricted to his parents' home. He has an ankle bracelet for monitoring. So he's not in jail, which I'm sure means a lot to him. But he is restricted.
And this is, it's hard to recall what a darling of financial markets and the media this guy was. And it's the same story, oh, the glory of it, followed by, oh, the shame of it. And, now everyone hates him. But, Bernie Madoff was made the head of NASDAQ. And everybody, seems to, come in that they've invented the better mousetrap. And then it turns out it doesn't catch mice, and everyone has lost their money. I joked with crypto that at least during the tulip craze, you got some flowers out of it. With this one, nobody gets anything.
Yeah, I think they will be great to see that the guarantors, there will be probably good list to start with assets recovery as well. I'm joking.
Good point.
Yeah. Yeah, no, I think this is incredible. So what do you think? What would be your advice? To I don't know, to some, or to because there's many, and as I said, many people in crypto who, even if they've done some wrong, let's say, investments, or the project is actually not correctly, happening.
Oh, I would be offering as much cooperation as I could to the prosecutors about all of the other players in the crypto industry, as well as anything I know about election law, corruption, and basically try and get credit for extraordinary cooperation and acceptance of responsibility, and being at the at ground zero of reforming the entire industry, which needs it.
Yeah, he acknowledged making mistakes, but denied claims. Right? This is something which he indicated. Yeah, and what about the 70 million funneled illegally as contribution to political candidates? What's coming out from this for him? Like, how was it done, and how possibly could be done this?
No, I think that's the point Eric was making. Was in the U.S. Criminal defendants get credit for cooperating, but it's really cooperation that leads to results. And so the question is, what concrete cases or investigations can SBF give federal prosecutors? And I think, he's going to have a lot of information about shady conduct in the crypto world, as Eric said, and those could be impactful cases, either criminal or regulatory. He should be doing whatever he can to help recover assets. If he decides that cooperation is the route, and then the political questions, because if there were illegal campaign contributions, then sort of exposing those and exposing the networks that the politicians and the parties were using would be very important. And so those are the types of things that a cooperating defendant who wants to get credit for, as Eric said, extraordinary cooperation, such that he gets credit and some type of downward easing of his sentence. That's what he's going to want to do. But we always tell clients, if you decide to cooperate, it's all or nothing. You can't sort of go halfway. And so a decision to cooperate means you roll over on your back, expose your belly, and give everything up to the prosecutors and the agents.
Right. So, for example, is he funneling money through other straw contributors? You can't do that. The irony of the American system is through something called super PACs, which are nominally not associated with candidates. You can give as much money as you want. He could have said, I want to elect Adam Kaufman to be dog catcher for Manhattan, and I'm going to start Kaufman for dog catcher and give it $70 million. It has nothing to do with Adam, but every time you turn on your TV, there are dogs barking Adam's name. He could do that. But I suspect that he gave to lots of candidates. If he could implicate, for example, candidates who had knowledge of, might have had knowledge or reason to know where the money was coming from, or that it was being funneled by FTX through other donors. So, corporations can't give the money to all its employees and say, here, all of you give money to Adam Kaufman. And that may have gone on too. So do candidates know? Do candidates' operatives know? And then there are also the other people who may have acted as conduits. So that's another possible area that no doubt I think they're going to be interested in.
And again, question to Tony.
Yeah, what Eric and Adam have talked about is absolutely not unique to the States. You will find in any Western jurisdiction, I think, or probably most criminal jurisdictions, that the authorities are always going to be interested in going up the food chain. So if you get the small people who catch the middle people, Eric rightly talks about the two who have already, in this case, sort of essentially coughed up, and this will apply further and further up the food chain. So the bigger and the higher people, the people more orchestrated, the greater planners, those higher up in the organization in terms of planning, are always going to be of interest to the authorities. And the only carrot which is there to be dangled is length of sentence. So the greater the cooperation, the more that the people are able to assist, the greater credit. That will not stop still, I'm sure, a lengthy sentence, but it will still make a huge difference.
The problem for Bankman-Fried is that he is, at least in this particular fraud, he is the top of the food chain. And so for him to get credit, there's nowhere for him to go but sort of outside of this fraud and expose other wrongdoing. And it will be interesting to see what he knows about if he goes that route. Not that we'll really see it, but we may see it play out. down the road.
Adam. Internally, that's absolutely right. So you're absolutely right. I think the only way it can go is wider. So I agree.
Yes, I think, there is a chance that we're going to see more interesting things coming out from FTX case, correct? There is a chance to see the entire, other people involved. There's definitely interesting aspect of celebrities supporting, the FTX, FTT, which was the coin. And also, I think, the big chunk of something that, needs to be at least understood, what's the involvement is the investors who put money and supported the entire project. So that's something to see. But anyway, gentlemen, thank you very much for your time. It was excellent. I really like it. This was crypto compliance. Thank you.